Martin J. Tannerman. Please be seated.
Good afternoon.
Good afternoon, Your Honor.
Boy, that was pretty poor. Is there an audience? Good afternoon.
Good afternoon.
What's he doing? Are you taking pictures? He's in contempt, bailiff. Did you get permission to do that? Did you know that in order to, well, actually, a new rule has just gone into effect. Did you know that, colleagues?
What?
And the rule
What
is,
the rule?
well, no, there was a time when you were not allowed to record or film anything in the courtroom. And you remember the O.J. Simpson case.
Which case?
You remember that one? And is it okay to do that or not? And there's been debates about it, and there's a strong argument that the court hearing should be televised. People should see it. And does it interfere with the course of justice? Well, anyway, now within our district, and I just issued a ruling. Did you know that?
No.
I've talked to my colleagues about it, and we now are streaming our oral arguments. And anyone can watch oral argument in this court. There's a website in the state of California that's it's the court website, and you can watch any oral argument here. So I think it's really important for the public to see what we do. So welcome to, this is now, who are these? This is Professor Glassman. How are you?
Yes, sir. How are you?
Okay, well this is a,
University of West Los Angeles, and we're here for the 20th Avenue.
my goodness, it's 20 years already. Well, welcome. We want to welcome all of you. And you have sort of a mini Supreme Court deciding this case today, because usually we sit in panels of 3. But we know what a great job you do, and we've been doing this for 20 years, that all 4 justices on this court have decided to come and hear this case. And we're really concerned because, as Justice Yagan pointed out, if there's a split in authority, if there's 2-2, how are we going to make a decision? But we'll have to worry about that later.
We actually have a fight in the alley.
Yeah, we do. We generally sit in panels of 3. And we have rotating panels. So we'll tell you a little bit about the court later when we meet. So now Richard Abbey, I'll just tell you very briefly, was one of the original members of this court. And since I'm the oldest guy here, I was an original member of this court when it was first formed in 1982. And he was a very unusual. He was a character, and I think he would. Enjoyed that epithet. He was the district attorney of Redding, California, not exactly a liberal bastion in politics. He was a district attorney who was opposed to the death penalty, and that was quite unusual. And he was a very independent voice, and a very fine justice, a great writer. And despite being opposed to the death penalty, the voters never voted him out of office. He had great integrity, and so we're really pleased to have this court in his honor. And we also, now we've included another colleague of ours, Richard Moss. And the winner of this so-called winner, and you're all winners. I mean, when you say win or lose, people talk about winning and losing in court. You're only as good as the case. And we want to see how you argue it and how you do, and we'll judge accordingly. Richard Moss was a dear colleague of mine and ours, who sat in another division of the 2nd District. He was on the original Warren Commission. Some of you weren't even born then. The Warren Commission investigated the death of President Kennedy, and he was a prominent member of that court, even as a young lawyer. He also sat on the Iranian Claims Tribunal when we were seizing assets, when we had our first disputes with Iran when the Shah was deposed. And so he's had a very distinguished career also on this court. And I just want, before we begin, I want to just introduce my colleagues to you. Sitting on my left is Justice Perrin, Justice Stephen Perrin, who's been on this court for how many years now?
17.
My God.
18.
Does time go by?
No, actually, it's been 19.
19 years, you see? Okay, are you sure you want to sit on this? Okay, 19 years. Sitting on my right is Justice Yagan, and you're the next senior member. No, you preceded Justice Parent, didn't you?
By 10 years.
Wow. We've been together that long.
29 years.
My goodness. And the youngest member of our court, and the one who is the newest member of our court, is Justice Martin Tangeman, who was a Superior Court judge for about how many years?
14 years on the Superior Court bench in San Luis Obispo,
Yeah.
and then 3.5 years now here.
My goodness. Wow. And my name's Arthur Gilbert. I'm the my title is the presiding justice, and that means I get to call the court to order and have to sign all the administrative orders and do extra work, but nobody helps me with it. So anyway, I want to welcome you all here, and we have the case of People versus Prescott, and the defendant is going to be or rather the appellant, who is the defendant, is going to be represented by Mr. Portillo, correct? Mr. Edgar, would you proceed, please? Now, you're going to be the timekeeper, is that correct?
That's correct.
And how long do they have for each?
Each advocate has 15 minutes, the appellant of the 15 minutes, 2 minutes for rebuttal, and I will vote time.
Okay, fine. Mr. Portillo.
Good afternoon. May
Good
it please the
afternoon.
court. Edgar Portillo on behalf of defendant appellant Peter Prescott. I respectfully request 2 minutes for rebuttal.
Yes.
So this case arises from an unlawful arrest of Mr. Peter Prescott by Deputy Drucker and Deputy Dawson.
He did have an outstanding warrant, didn't he?
Correct. That is correct. And that was
Don't the
caused-
police have a right to arrest people who have warrants?
Absolutely.
Outstanding?
But the manner in which the deputies went about the arrest and the procedural aspect of these circumstances were in violation of Penal Code 841. Penal Code 841 explicitly states that an arresting individual must inform the arrestee, in this case Mr. Prescott, of the intent to arrest him, of the cause for the arrest, and of the nature of the arrest. Neither of those three were satisfied with the deputies in the execution of the arrest. Now,
Because you're asserting that that communication has to be in words as opposed to in conduct. Is that correct?
to an extent, certain case law allows for, certain cases have shown and reflected that there are exceptions with strict compliance to the code, but none of those exceptions apply to the instant case, given the circumstances.
But I think that I'm asking you a slightly different question, and that is, there must be communication under that code,
Oh, yes,
under the
correct.
code section.
Correct.
But your argument is that communication has to be verbal instead of by conduct. Is that your argument?
As it applies to these facts, yes.
Because an officer could clearly communicate an intention to arrest by nonverbal conduct, correct? Do you concede that?
If the circumstances and facts are correct and appropriate under the circumstances, then yes, that is a possibility.
Okay.
But as it applies to this case, no, we do not.
And so, as applied to this case, what about what kind of conduct would qualify? Now that we've opened up that area for inquiry, what kind of conduct would qualify to make it obvious that you're being arrested?
One of the more obvious exceptions to strict compliance with the code is if the individual, the arrestee, the person to be arrested, is observed by the arresting officers to be in the commission of a crime. Now, in this case, the deputies testified that prior to making initial contact with the defendant, they observed him in possible violation of Vehicle Code 23111. Vehicle Code 23111 allows for an arresting officer to cite the individual for littering. However, in this particular instance, in this case, neither deputy was set on citing Mr. Prescott for the offense, nor was he not charged, let alone convicted of the offense. Now, the basis of the arrest was that he had outstanding warrants, which the officers did not find out until after they ran his name. Deputy Dawson ran his name in the system to look and see if he had any arrest warrants under his name. In fact, this issue came before the trial judge, and the prosecution wanted to make the outstanding arrest a separate charge, and Mr. Prescott's resisting of the arrest a separate charge from the Vehicle Code section. Mr. Prescott was not charged with the offense of the Vehicle Code, and because of that, with regard to that particular aspect of the case, does not constitute a crime, and so the basis for the officers making initial contact with the defendant was not because he was observed in the commission of a crime. Therefore, that exception to Penal Code 841 does not apply to this case.
You mean ashing cigarettes in the street isn't a crime?
It is.
It is a crime?
If there is sufficient
That's
evidence.
news to me. I didn't know. Is it? So if you're smoking a cigarette and you put some ashes in the street, that's a criminal offense?
Well, pursuant to the code as it's currently written,
Yeah.
and the legislative intent is to reduce littering, it could be, and yes. However, as I previously mentioned, Mr. Prescott was not charged with the offense or convicted. Which,
Does he have to be charged with the offense? Somebody can commit a minor offense. The officers arrest him for that offense, but then it escalates into something much greater. So then the district attorney says, you know what, the first offense, so small, even though it's an offense, look what he did after that. So they elect to charge him with the more serious offenses. That happens all the time.
Absolutely. However, in this case, the initial contact between the officers and Mr. Prescott was consensual. There was absolutely, the situation did not escalate until after Deputy Dawson communicated the code 1015 to Deputy Drucker, who was standing next to the defendant. Upon hearing the code, Deputy Drucker, without informing Mr. Prescott of his intent to arrest him, grabbed Mr. Prescott's arm and then proceeded to attempt to arrest Mr. Prescott. Now, the issue here is that the conviction for Penal Code 69, resisting an officer, that crime was incidental to the deputy's omission to inform Mr. Prescott of their intent to arrest him and of the cause for the arrest.
Well, but let's be practical about this. You're saying that the arrest fails because Officer Drucker didn't say, "I'm arresting you," when he put the handcuffs on him. Wouldn't any normal citizen know they were being arrested when officers took out handcuffs to handcuff them?
It's reasonable to make that inference. However, given the current state of our politics and society, it's not unreasonable for Mr. Prescott in that situation, thinking everything was okay, providing his accurate name and date of birth, thinking he was going to be cleared because he did testify to that.
Well, he knew he wasn't being cleared when the handcuffs came out. Right?
Presumably, he testified to the contrary. So at this, based on the
He
record,
didn't think he was being arrested as he was being handcuffed. That is the defense position.
pursuant to the record, yes. He did not know he was going to be arrested. He did not know he had outstanding warrants for his arrest. So based off of that, Mr. Prescott did not know, in fact, that he had warrants out for his arrest, nor did he know or make the inference that the Deputy Drucker and Deputy Dawson were going to arrest him. Now, it might be raised by the government that Mr. Prescott should have been aware of that possibility given the fact that two officers approached him. Now, that point
I'm
is...
not talking about the approach. I'm talking about putting handcuffs on. I mean, let's isolate just to that fact. What other reasonable explanation would there be other than you are being arrested to having police put handcuffs on?
Mr. Prescott did mention that he is well aware of plenty of police brutality incidents where sometimes an individual may be placed under arrest or excessive force may be used to put them under arrest for an unreasonable situation or a misinterpretation of the facts. In this particular instance, Mr. Prescott did not think he did anything wrong. In fact, prior to making contact with the officers, he nodded over to the officers as a gesture of saying hello. The officers casually stepped out of the vehicle, approached Mr. Prescott. And so, upon being grabbed by the arm by Deputy Drucker, Mr. Prescott's immediate reaction was tensing up and asking what's going on. But Deputy Dawson proceeded to assist Deputy Drucker in attempting to arrest Mr. Prescott. Mr. Prescott then asked once again, what's going on? Is everything okay? Am I under arrest? He explicitly asked the deputies, am I under arrest? As the deputies escorted him to the back of the patrol vehicle. Neither deputy responded to his question. He was slammed against the patrol vehicle, then asked one more time prior to being tased by Deputy Drucker. What's going on? Neither deputy answered his question. Neither deputy told him he was going to be placed under arrest, which could have been done within those circumstances.
Didn't he ask, why am I being arrested?
He asked, am I being under arrest? And one of the deputies replied, no, you're not. We just want to search you. And so here we have Mr. Prescott, as he's being guided, escorted to the back of the patrol vehicle, thinking he's only going to be patted down, searched. Now, as we know, pursuant to the record, Mr. Prescott was not found to be in possession of any weapons. He did not pose, based on the testimony of the deputies, that he was an imminent threat to put the deputies in a reasonable fear. He did not threaten either deputy throughout the course of this entire incident. He did not yell obscenities. He did not swing any punches. In fact, he did not lay a hand on either deputy. And so it wasn't until, so on two grounds, Mr. Prescott raised four issues on appeal, two of which are in argument today.
Okay, so do you want to move on to the next issue? Is that about whether what force is required to constitute resisting?
If the court wishes, I can proceed to
Unless there's any other questions.
Unless there's any-
Whatever you want to do. All right, unless one of my colleagues has some questions about
Well,
this first issue.
let's assume you're correct. There is a violation of 841 of the Penal Code. By your theory, if Mr. Prescott had been some master at karate or judo, he could actually punch these two officers out, killing them, and he would have a complete defense to homicide. Do you agree to that?
I do agree. That being said,
Does that sound reasonable to you?
that
You can
sounds-
kill two police officers who are trying to arrest you for 4 warrants, and you get to kill them without any penalty because the officers did not tell you that you had 4 outstanding warrants.
I take that point. However, under these circumstances, Mr. Prescott did not have any prior convictions for resisting arrest. He did not have any history of...
Okay, I'm sorry to interrupt you. I'm going to amend, I'm going to add something. Perhaps your argument might be a little stronger were these plainclothes officers. That might be a different story, but were the officers in wearing uniforms?
Yes.
So you think that if officers wearing uniforms approach you and they arrest you and you have no idea why they're arresting you, can use any kind of force to avoid that arrest? That's what Justice Yagan's asking.
Oh, my apologies. I misunderstood the question. No, the answer to that question is no. Given under the circumstances, they're without getting into grotesque detail, they're a defendant, an arrestee may use reasonable force under the circumstances and in reacting to an arresting individual's attempt to arrest him.
No, I understand that, but I want to follow up on what Justice Yagan was asking. If the defendant's a judo expert and he has no idea why he's being arrested, accepting those facts, he can use any type of force, even lethal force, against the officers?
No.
Okay. Then how did you I just want to make sure we're all on the same page here. What did you misunderstand when Justice Yagan asked you that question?
I don't recall. But
Okay.
now
All right.
that I do understand the question completely,
Yeah.
I can affirmatively say in response, no.
Yeah.
You stirred my interest.
I apologize.
No, don't apologize. That's good.
Let's assume they aren't officers. They're just 2 people stop him on the street, put their hand on him. And if he's an expert in the use of his hands as lethal weapons, you're telling us that he could use his art to kill 2 people who just stopped him on the street?
If it's reasonable under the circumstances.
Now, I think you left that out in the earlier comment. So if it's a police officers, does the rule somehow change concerning self-defense?
To an extent, and here's why. The legislative intent of Penal Code 69 is to preserve the safety of the arresting officers. For example, Graham v. Connor is the leading case when it comes to the use of excessive force. And that, when it comes to an issue of excessive force, the Supreme Court determined that it must be analyzed from a reasonable, objective standpoint from the officers on the scene. And so as that way of analyzing the case applies to the circumstances in this particular case,
As perceived by whom?
as perceived from the officers, when it comes to a discussion of excessive force. And so the argument here is that Mr. Prescott's reaction to both Deputy Drucker and Deputy Dawson's attempt to arrest him, given the circumstances that 1, he did not know he was going to be arrested, 2, he was not told he was going to be arrested, and 3, he did not know what the cause for the arrest. His only reaction to either deputy when they attempted to arrest him, Deputy Drucker cites that in his initial attempt after grabbing Mr. Prescott's arm, Mr. Prescott allegedly raised his elbow, almost hitting his face. He did not say Mr. Prescott hit his face. Now, aside from that, there's no other instance where the deputy, either deputy, states or testified that Mr. Prescott attempted to hit or make contact with either officer, either deputy. The deputies do testify that after Mr. Prescott was tasered, Mr. Prescott fell to the ground, both his hands were under his stomach, and they were in fear that he might have a weapon on him because they did not have a chance to pat him down and make sure he wasn't armed and dangerous. Now, that being said, that's circumstantial because Mr. Prescott had just been tased. He collapsed. He was tased a second time. It's on top of that, after the second tase, Miss Deputy Drucker was on top of Mr. Prescott, applying pressure to his lower back, and so it's reasonable for Mr. Prescott to have difficulty to pull his hands out of his
Okay,
waist.
at that point, let me just ask you something and tell me I'm going to just give you a supposition or a statement and tell me what's wrong with it. Somebody is approached by police officers in uniform and they arrest him, as happened here, and the person has absolutely no reason to believe they should be arrested. They might ask some questions, but the officers say, we're handcuffing you. What's wrong with saying that under those circumstances, instead of fighting the officers or resisting, you comply and then bring your complaint before the courts at a later time, rather than escalate a situation in the street, even though you may be completely innocent of any crime, the officers made a mistake?
Absolutely, that's a fair point. But as they say, hindsight is 20/20. In this particular circumstance, Mr. Prescott, in that specific instance, he was on his way home after going to the liquor store, just minding his own business.
No, I understand. That's my scenario that I'm giving you.
Okay.
Just minding your own business, someone who actually does not have any warrants.
Yeah.
There might be some kind of civil action later on. There might be some kind of reparations if there's injuries and so on. But under that circumstance, what's wrong with the concept or the doctrine of submit to a police officer and fight it out in court later?
There's nothing wrong, but in actual practice, there's plenty of individuals out there, one of which can be Mr. Prescott, who actually has a fear that there's always the opportunity or chance that an officer can be an abuse of authority, and in this case, a failure to advise and omission of informing Mr. Prescott of the reason and the basis for his arrest led to the slight use of force by Mr. Prescott, which only constituted of him moving his arm and yanking his arm away from Deputy Drucker.
If you'd like, Republic, your time's up.
Thank you.
Thank you.
And we'll hear the people will be represented by Natalie Harabedian. Ms. Harabedian.
May it please the court, my name is Natalie Harabedian and I represent the respondent. So the first issue...
One moment. You're going to have to speak a lot louder.
Can I move this? The first issue on appeal is whether the officers were engaged in the lawful performance of their statutory duties within the meaning of Section 841 and use the appropriate means to effectuate the arrest. As I will present to you, the officers were certainly engaged in the lawful performance of their duties, and the force that they used to make the arrest was reasonable given the circumstances.
Time out. You're ahead of the game.
Yeah.
There's a
elaborate.
process here somewhere.
Yes, I'm going to
The
elaborate.
whole thing turns on the announcement of the arrest. We're not disputing. An officer walks up and says, I am going to arrest you. A man says, no, you're not, and dukes it out with the officer. That's not what we're talking about. Here we're talking about grab, force, and a statute that says you shall announce arrest. Now, how does that play into your formula?
Certainly. So Section 841 prescribes the manner in which the officers, 1, notify the appellant that he's being placed under arrest, 2, the cause of the arrest, and 3, the authority to make it. Now, appellant states that the officers didn't comply with any of those factors. So I'm going to start with the authority factor because that's just not contested here. I mean, they were wearing their uniforms, they had their badges on, they were in their marked police vehicles.
Well, I have a question for you.
Yes.
Do you concede that the defendant was not advised that he was under arrest?
Verbally, yes. They never told him you are being placed under arrest.
And do you concede that the defendant was never advised of what he was being arrested for?
I do.
You concede that the obligation to do those two things is mandatory?
Certainly, depending on the circumstances.
And why, under the circumstances, were they not mandatory here?
Okay, so as to the notification prong, the fact that he was not notified that he was being placed under arrest, the facts and the circumstances in this specific case provide sufficient justification for him to have known that he was being placed under arrest. Specifically, whenever the deputies approached the appellant and they asked him for his identification, the appellant gave him the identification. Deputy Dawson went back to his vehicle to run his name. Appellant knew this was happening because he testified on page 344 of the transcript.
Is there some case or statutory authority for you that you don't have to do this if the defendant should have figured it out?
Yes. So the case
What is that authority?
The case of Allen versus McCoy, which is a case dating back to 1933, the California Court of Appeals held that whenever the officers said, "Throw up your hands, we are officers," that was a sufficient indicator of an arrest. Furthermore, in People versus Rios, the California Supreme Court held that whenever the officer said, "You are busted," that was a sufficient indicator of an arrest.
Where was the busted? I must have missed that in here.
Yes.
The officer said, "What?" when they hooked him up. They didn't say a word, did they?
In the People versus Rios, or are we talking about this case?
Our case.
In our case, they said, "Place your hands behind your back."
I'm going to back up,
Yes.
even before that happens.
Okay.
Why did they even stop and talk to him?
Because
Do they have a right to even stop him?
I mean, they were just engaged in a casual conversation because he was ashing his cigarette on the floor.
And I've just learned something. Ashing cigarettes on the floor, it was outside in the street, right? That's a crime,
It
apparently.
was a California, it was a vehicle code violation, correct?
If you're smoking a cigarette and the ashes fall in the street, you're guilty of a crime?
Well, the officers didn't know if they were going to actually cite him for the crime or just give him a warning.
What
but
is
yes,
it? No,
it's
wait.
a violation.
We learn something all the time. We judges don't have all the law at our fingertips. So I see people smoking. I'm not a smoker, so I stay away from them. But I see people smoking, and ashes fall out of the cigarette on the ground. That's illegal.
It's a vehicle code violation, yes.
A vehicle code. So if you're walking with a cigarette.
Mhm.
And it's a vehicle code because I guess the ashes go in the street, right?
It
And
applies
the
to
streets are part of the. Boy, I'm learning something new. Did you know that, Professor? All right, I'm sorry, you're not part of this. I didn't know that. Okay,
Yes.
so that's the law that they broke, that he broke.
Right, but that's not the issue that's on appeal.
No, I understand that, but the point is, I'm just thinking, if somebody's walking down the street minding their own business and not ashing, quote, ashes in the street. Can officers just stop you for no reason at all and start asking questions and telling you to wait while they check if you have warrants because you look a little suspicious?
Well, yeah, because at that point he was.
No, not he, in general.
In general, I mean, if you're in
When you-
violation of a crime.
No, I'm not saying violent. I'm walking down the street
Okay.
and the officers just stop me. It's one thing to say, "Good morning, nice day, isn't it?" And they start asking me all kinds of questions. Can they do that in this country?
Yeah, well. you're
United
not in-
States, they
at
can do that?
At that point, you're not in custodial. You're not in custody, and they're not interrogating.
Do you have to stay and engage with them if you don't want to? Sorry, I'd love to chat, but I'm on my way. I'm late for a meeting. I got to be in court. I'm late. And they can walk away and the officer can, "Hey, stay here. We're talking to you."
I guess it depends on the circumstances, but he was not in custody at that time, so he was free to leave.
Okay.
Did I address your question? I'm sorry, I forgot.
Okay, I forgot it too.
Okay.
It's my fault.
So,
No,
no,
I'm fascinated by the response. It was a very candid and forthright response that you made to Justice Gilbert's statement. Police officer walks up to you, badge shining, and says, "Hey, I want to talk to you." And you say, "Officer, I respect and admire the role you play in our society, but I don't want to talk to you. Goodbye."
I don't like cops. What if they even say that? I don't
And,
care for the police.
And he starts to walk away. Can he do that?
I mean, it depends on the circumstances.
That's the
but
circumstance.
It's
Then
not
he
a
gave-
wise decision to make.
He
and-
gave you the circumstances. That's all. A person walking down the street. We're doing this incrementally. So Justice Perrin's question is that permissible?
No.
Okay.
Okay, now let me stop you there. Your statement to us was that a person is put on notice that the officer is acting in the course of his duties by something that the officer does that may not be the declaration you're under arrest. And here the declaration was, hey you, we want to talk to you. And the guy says, I don't want to talk to you. Now, isn't that sufficient notice for the person to be apprised of the fact that these officers intend to arrest him?
I don't think it rises to the level of if their intention to arrest him or to convey to them what they're gonna, cite him for or whatever the circumstances are.
At which point the officer puts out his hand and touches him on the shoulder and says, I wanted to talk to you. Now can the person just shrug and say, please get your hand off me, I don't want to talk to you? Is that okay?
No, because you are resisting an officer at that point, and that's a Penal Code Section 834 violation.
Okay.
Okay.
I'm sorry to keep stressing this, the cigarette ashing, driving me nuts. Is it okay for the ashes to go on you found the section?
And it's not in the vehicle code,
Oh, it's not it's public health and safety.
3374.
This
penal
doesn't
code.
count against your time while I look this up. Wait, where is that? I
Right here,
don't see it.
374.
Oh, 374?
Here, right there.
My goodness.
I do all his work for him.
Yeah, littering. Willful or negligent throwing or dropping, causing waste matter and so on. All right, fine. Of course.
And it's defined as
Yeah, I
cigarette.
understand. So if I'm walking down the street with a cigarette and the ashes fall on the sidewalk, I'm guilty of an offense? I mean, there's all kinds of laws. And if anybody got arrested for that, if the press would be covering it, everybody would say, give me a break. That would be, if an arrest like that came in, I'm going to make a supposition, Justice Yagan, if an arrest, as a trial court, when you and I were both on the municipal court.
He would have been charged with littering.
Yeah. And what would you have done with a case where he was smoking a cigarette and the ashes dropped on the sidewalk?
365 days, Ventura County.
Yeah. He's a tough sentencer. Boy, I mean, it goes to show the law operates within a context. We'll talk about that later when we have a discussion with you later.
Okay, and Your Honors, I'd just like to clarify the fact that none of this has to do with the ashing of the cigarette. It's all about, they stopped him just because they weren't sure if they were going to cite him or just give him a warning. But
Why
it's
did
the
they
arrest warrants
Why
that-
did they stop him?
Due to that violation.
Due to that, you said, wait a minute.
I'll-
You agree that if that violation did not occur, right, this ashing,
Correct.
as it's called, then this would be a different case. They would have no grounds to stop him. Do you concede that?
Yes.
Okay, good.
I do.
Okay.
Okay. So.
Does it sound to you? Here's another argument that's made in these kind of cases. This is a pretext. It's a pretext to stop him. Let's see, I want to stop this guy. What can we do? I think that tail light looks a little dim, so we'll stop the car. We have cases like this all the time. I've thrown cases. It's a pretext. Give me a break test, frankly. And so this just strikes me as, are you serious? You're stopping the guy because some ashes went into some people would say better it goes in the street than on the sidewalk where people are walking. And they bring the ashes, stick on their feet, they go in homes or whatever, or you put the ashes in some brush that could catch on fire. He's doing something that's more reasonable.
Right.
You should carry an ashtray with you.
I mean, the officers need to have a reasonable suspicion that there is some sort of crime that they're going to stop them for. They can't manufacture
Yeah,
it.
okay. So there was a basis for them to stop him.
Correct.
So I suppose you're saying that the peace officers on an individual basis can elect to not follow Penal Code Section 841?
I'm not stating that, no.
No? Well, why do they get to ignore it?
Well, the circumstances of this case provide, again, sufficient justification for him to have known that he was being put on notice of an arrest whenever the officer stated, place your hands behind your back, and after the appellant knows that they're running his name in the vehicle. So he should have known. And then again, I cited Allen versus McCoy and People versus Rios, where the terminology wasn't exactly you are being placed under arrest. It was stated differently, but and those cases stated that they should have known in those circumstances.
But there's another issue here too, as part of 841, isn't there? And that is that that's a two-part requirement. The second part is
The cause.
you have to be advised as to why you're being arrested. And I assume that under these facts, you are conceding that this defendant was never told. Is that, would you concede that?
I do concede to
Yeah.
that, correct?
So there has been a violation of a mandatory duty. You are conceding that.
No, because given the facts of the circumstances, the officers didn't have sufficient time to apprise the appellant of the cause of the arrest because he immediately began resisting the officers. Now, the Allen court that I talked about earlier had stated that it is sufficient if the officers convey the cause of the arrest at the earliest occasion of
Well,
the
I'm
arrest.
just going to interrupt you because I want to get to this point
Sure.
right away before your time runs up. And that is that, well, is the rule that you are articulating this, and that is officers can charge forward, say, put your hands up or start to handcuff, and then as soon as there's any resistance, that's all we need. So 841, which imposes a mandatory requirement of telling the defendant that they are being arrested and why, unless, of course, the defendant is fleeing or in the act of committing a crime, neither of which applies here, okay, that it's good enough to just rush and handcuff. That complies with 841. And how do you square that with the policy reasons behind 841? That's really my question.
Correct. No, I don't think that the officers, as soon as they see an arrest, they can justify that they don't need to, a resistance, they can justify that they don't need to convey the cause of the arrest. Every circumstance is going to be different. It depends on the situation. It does state in Allen versus McCoy that an officer can state it at the earliest reasonable opportunity. Now, yeah.
I'm sorry to interrupt. You've cited Allen versus McCoy, right? 1933 case.
Mm-hmm.
This was a case of desperate criminals who killed in cold blood. They gave somebody a lift. They shot the guy in the head. They raped the woman, shot her in the head, thought she was dead. She wasn't. She told the police. They grabbed a police officer and held him hostage. The car overturned. They escaped. Then they went into this place in a wilderness where there was a cabin. There was a car there. Police officer said, this must be the gang. So there was a reasonable mistake. They burst into the house. That's a fact situation that's so different than this. This is, so we have to look at the facts of the case and see from where the law comes from that case. In some case, a reasonable mistake. There's a gang. Here, some people with a woman living in this wilderness shack. A few days after this crime occurred, they have police officers looking everywhere. That's a much different situation there.
You can answer and then your time.
Yeah.
I agree. It is a very different situation, but that case is not dealing with the criminals. It's the Allen who was actually apprehended by mistake.
Yeah.
And they stated, throw up your hands. We are officers, and that was sufficient. And the only reason that this case even it's a civil case, went to court is because it was a false imprisonment claim, and they accidentally arrested him.
And they apologized immediately when they saw who they were. They all shook hands and they said it's okay. And that was the end of it, right, in that case?
Correct. Yes, they
Isn't that
apologized and they
a
said
far
it was all
different,
okay.
I'm going to keep you another minute because we've interrupted you so much. Isn't that a far different situation than this one? You can't take what I'm suggesting is we have a rule and you just can't blindly apply the rule in every situation. This was killers with guns who would threaten to kill a police officer and shot somebody else. It's a whole different story, right?
It's very different. The factual scenario is completely different, but there are additional cases that will support the same position. For example, People versus Villarreal, the California Court of Appeals had held that the officers didn't have sufficient time to apprise the appellant because the appellant immediately assaulted the officers, and it was justified under that court. So, and that situation isn't exactly as extreme as Allen versus McCoy, it's more reasonable and fitting to the case that we have at hand. So, of course, it depends on the circumstances. I'm not saying that officers can just disregard Penal Code Section 841 just because there is resistance, but in this case, there was actual forceful resistance for the officers to not have an opportunity to take a step back and say, by the way, the reason we are arresting you is because you have a warrant for this out for your arrest, you have a warrant for that out for your arrest. He just immediately, appellant stated that his immediate response was, no, what is this for? But no, the immediate response was not that. The immediate response was, no, I'm not going to comply. He took a step back, and as soon as the deputy tried to grab his left arm, he immediately flung it around and almost struck him in the face. I mean, this situation doesn't give them a reasonable opportunity to tell them this is the cause, because he may flee at that point.
Okay, thank you.
Thank you.
We'll have a brief rebuttal.
And so the appellant would like to contest 3 points. First off, Alan D. McCoy, as previously mentioned, there's very small, not much similarities to the present facts in this case. As previously mentioned, Alan D. McCoy was a civil case, involved a claim of false imprisonment, and in that particular case, the person that was arrested was confronted by multiple officers bearing weapons in his face. So there was absolutely no doubt, given those circumstances, that the defendant or the person that filed the civil claim, given those circumstances, would have been, under those circumstances, known that the officers, with their weapons bearing on him, that he was going, there's a good opportunity he was going to be placed under arrest.
What do you think the purpose of the law is that says an officer shall announce? Why do
To-
they have that?
To minimize the probability that the person to be arrested resort to violence or resistance, and to make the interaction between the RSC and the law enforcement officers more amicable and safety for both parties.
Well, I'm not sure about the amicability part, but the business about notice, you seem to concede the purpose is to get everybody on the same page that something's going down.
Correct.
Well, wasn't that accomplished by the arm extended for the defendant? At that point, he knew what was coming.
Not when moments leading up to that moment, Mr. Prescott thought everything was okay, and he gave his accurate name and date of birth, and thought he was just going to be, his name was going to be run in the system, and he would be cleared and let go.
Time is up.
Okay, thank you very much. We're going to withdraw to our conference room to discuss the weighty issues in this case, and then we'll return. When we return and we get on the bench, you don't have to stand up, okay? Is that a deal? Everybody can remain seated, and we won't be too offended if that happens. Okay. Thank you. Good job, both of you.
Seated. Court is back in session.
All rise. No, just kidding. Just kidding.
And we're not used to the cameraman over here to the right either.
No, that's...
It's keeping us
No, we have to get used to this. So anyway, we've been discussing this in our conference room, and actually, we've done this for 20 years now, and we've had winners. We call it, I don't like to refer to a person as a loser. We talk about it because they're not, and it reminds me of someone else that uses that phrase too often. We like to refer to the party that prevails. And generally, you're only as good as your case. And of course, we're not deciding the merits of the case, we're deciding how you present it. And we are a divided court. We were once before. And frankly, I think, and you're actually both winners. And so you're both winners. I like to quote Justice Yegan when we were talking about it. He said both of them and their arguments are in equipoise, and I thought that was a perfect phrase. And we threw some really difficult questions at you, interrupted you a lot. That's what happens in the real world. Not always. Our court is an extremely, you can tell, an active court, and I like to think of us as a friendly court. Some judges, they're sitting there and it's like an oil painting. And you don't know what they're thinking. When I was a lawyer and I had to appear in front of judges who just stared at you, I wanted some connection. I want questions. I want to have an argument, a discussion. Not an argument. We call it argument. And we look upon ourselves as a court that has discussion with the lawyers. And when we have that atmosphere more comfortable with a little humor, we get a better argument. And if we get a better argument, it helps us write a better opinion. So, it sort of works in that fashion. And I kind of like to open it up to some questions that you may have of us, some of the students. Yes, in the back.
I was actually wondering as to when the appellant was arguing, how come you didn't ask him for any to cite any cases as authority?
Well, there was we know what that's a good question. We know what the authority is, and he does as well. I know that briefs were written in the case. So we're really talking about the argument. We could have asked for some authority and mentioned certain cases. That's true. Mrs. Harabedian kept mentioning this one case, which I thought was kind of an extreme case. So I was going to hit you back on that case. There's some other more recent cases that work against you. And this was an old case back in the 30s. Maybe the views were a little different about the application of the law. So we could have said, what about the so-and-so case? Doesn't that work against you? We could have done that. Actually, the cases that we would be citing, though, the ones that I saw, were more extreme cases where it's obvious what's going on. Here, it was more subtle. So there was case law that would support that would support Mr. Portillo. But I didn't need to cite those cases. He said, see, this is what's happening. So we're trying to, and one thing we were talking about in Chambers is we never see 841 cases, do we? We've never seen cases like this because generally we never, when somebody's being arrested, every case, I've never seen a case. It just occurred to me when you mentioned it. I've never seen, none of us have, you? None of us have had a case like it because generally it's the resisting arrest, other things that happen. But if you don't say to the person you're under arrest, that's going to be a reversal. Generally, isn't. Police officers some of the questions were police officers wearing a uniform. Come on, aren't you supposed to just submit and let's fight about it later? You don't start fighting with the officer. Do you have any comments or any other questions? Yes? No? Come. Don't go and blight.
This is the novice justice. You made reference to 841 as being mandatory. Are there any exigent circumstances here justifying the arrest without complying with the requirement of 841?
Well, those are the questions that I was posing, and that's what those questions were designed to draw out. All right, it's mandatory, so tell me why it doesn't apply. Of course, there are some exceptions, as we know from the materials. As Justice Gilbert has just announced, none of us have ever seen one of these cases before. This briefing is the briefing that we have seen on Penal Code 841 in our careers, evidently. So I was trying to draw something out on that. I wanted to see if the prosecution was going to go to, fleeing or attempting to flee or caught in the act, which of course the facts are set up to not provide that safe refuge. So you're asking me a question that really is a question being reflected to the students who are arguing. I don't have an answer for that question. I wanted to know what their answer was.
You've asked the question we were asking ourselves, but there is a slight analogy to this, and it's a section called 844, which requires that police officers, prior to entering the premises to execute a warrant, have to give knock and notice of why they're there, unless, the law tells us, there are exigent circumstances that should suggest to the officer that would be improvident and increase the dangers involved.
Or they're getting rid of the evidence. So there's a drug place, and they hear people running around the house, and they hear toilets flushing their stuff. They'll break in. You hear that kind of thing all the time.
But again, you're asking, can you stop the ultimate result of the prosecution for an offense where the police have erred? And the answer to that is, well, yes, in an 844 case, the evidence that would be achieved by going in would be suppressed. The question is, what if the person tries to prevent you, doesn't know why you're coming in because you thought as a police officer you're coming in, doesn't announce what it is, the door comes flying off the hinges and you're standing behind it, you hit the officer. What's that? It's just a thought.
You know, well, Justice Yegan we were talking, and about in the real world how we would decide this case. Now, you know, Judge Yegan pointed out, and from our experience, there's the law, and you can be literal in some circumstances, but some circumstances it does. First of all, this guy is on probation. He knows damn well why the police are arresting him, and I asked the question, you know, well, wouldn't it have been better for him just to merely submit, and then if he thinks there's a mistake, he can say it later, because it tends to escalate. Now, it's one thing to draw away, but when you draw away in such a manner that there may be an injury to someone himself, if not the officer, it's a different story. And in the real world, your view is what about this case?
I would suspect that insofar as 841 is couched in mandatory language, officers shall do 1, 2, 3. I'm going to go out on a limb and say that I think that's directory only, meaning that's what you should do. But if you don't do it, there's really no penalty for that. It's not like, you know, you're suspended as a peace officer, or if this guy does inflict great bodily injury on you, well, the case is dismissed and the officer gets to limp away and he can't be a peace officer anymore because the guy was a judo expert and just thrashes the officer or kills him. So there is a dichotomy in terms of directory, or I think the word is, what is the word, directory or
Mandatory.
Or mandatory? I think it's going to be directory, although we've never seen that case.
And generally, there are facts in which, you know, a reasonable person looking at these facts,
There's also a doctrine called substantial compliance in the law.
Right.
Did the officers substantially comply with the knock notice requirements? The officers substantially comply with notice provisions. Now, anyone who's got 4 warrants knows, well, you know, I'm supposed to go to court, or, I hope if I give a fake name, they won't find out who I am. But generally speaking, a person with 4 warrants is going to know that the officers aren't just fishing around for something to do. They're required by a magistrate. It's not like there's an election here. Some magistrate, a judge, has said, when you find Peter Prescott, cuff him up and bring him to court. So that's what the officers are doing.
See, now there's case law. One of the cases you probably read was People versus Superior Court in Merced, where the arrest was thrown out by the courts. And that's where the officers saw marijuana plants, and they suspected, they weren't sure that they were marijuana plants. They didn't have quite the expertise. So they knocked on the door and they went in the house, and the father let him in and showed him where the son's room was, and there were marijuana plants, and then they're looking for the son, and they find him, and they just arrest him on the spot. That was the court. The court said that that's not how we do law in this country. That's not how we enforce the laws in this country. So you have to look at each fact, and you have to find what's reasonable. And this proves a point that I've raised many times. We get as close to certainty as we can, but there is no certainty in the law. There's no certainty in life. We get as close as we can. That's why lawyers, when anybody goes to a lawyer's office, can the police do this? Can we do this? The lawyer, what are the 3 words a lawyer always says? It all depends. That's right. So that's, I think one other thing I'd like to do before we break, I think we're going to have a little social hour. We should talk about your presentations a little more. What I thought you were, and I'd like to hear from my colleagues in that regard. I thought you were all very familiar with the facts. Your poise in the court was just excellent. You stood your ground. You were respectful. You made your argument succinctly. We understood what the argument was. We interrupted you, and all of a sudden you're stuck and you're thrown. You're given all these other questions that we have, and you have to think quickly on your feet. I think that you both did a very good job, and were quite well prepared. And I think Ms. Harabedian, we really gave you a rough time. And you'd be in the middle of something, and we interrupted a few times. And I thought you stood your ground and were and maintained the poise. And we asked you some pretty tough questions. We asked both of you tough questions, and I think we create a comfort level here that you might not have in another court. But I think you were both so thoroughly prepared, and you handled yourself in a very professional manner. And I think you're going to be fine lawyers when you graduate. Do you have any comments, Steve, about that? Anyone else?
He said it all.
Well, I'll add a few things. I mean, I agree with those observations about how well prepared you were. I thought that was impressive. You were ready to field and answer questions. Appeared to be confident. That's really important. You made it shaking inside. I don't know. I would be if I were in your shoes in this, but didn't show. You appeared to be very confident of your position. That's a strong plus. You appeared to master your material. A couple of suggestions for the future. Really listen carefully to the questions that get asked by the panel and focus on that question and answer it. You did what a lot of lawyers do sometimes, and that is take a question as an opportunity to present a strong part of your case, which may not be directly in response to the question. While I understand all of our inclination to do something like that, it's not always the best practice. You're going to find out really what the justices think about your case by the questions that they've asked or where their concerns are. It may not be on the part that you want to emphasize as the strongest part of your case. They may already be with you on that, but they may need some help getting over. I asked both of you questions, for example, in areas where I thought this is the toughest part of your case. It convinced me to come over to your side on it. And sometimes you didn't go right with that question, but went again to a strong part of your case to emphasize why you should win instead of helping me get over. So be really careful with that. That comes as constructive only in view of a job very well done. Something else that you might want to consider is incorporating into the argument some policy argument. What's the policy behind 841? And why is that policy either furthered or not furthered by the result that you're advocating or that your adversary is advocating? That would have helped to strengthen it a bit more. But overall, your performances were quite strong and quite good. Those suggestions are for constructive purposes only.
So just listening to Justice Tangeman, and I'm reminded of a story, well, my own story. I was a public defender, and I argued many times at the California Court of Appeal, and I wasn't intimidated one bit. For some reason, I appeared in front of some very severe judges, and so I was just ready for anything. And so I got a case in the California Supreme Court, and my wife asked me the night before, "Are you nervous about arguing in the Supreme Court?" Piece of cake. So I walk in there. This was 1975 or 6, a long time ago. And there's just a different atmosphere. And the clerk says, "All rise, California Supreme Court," And thank God I didn't, they called another case first. Man, my heart was jumping out of my chest. And I was truthful to my wife, but I was absolutely wrong. And boy, it took me about 5 minutes before I could come down to earth. But you both have poise. So, way to go.
Okay.
Justice Gilbert, can I just say that, as this critique illustrates, to my knowledge, there's one law school class in the country, right? Of all the large, prominent law schools, of all the out-of-the-way law schools, there's one class in which students work on a practically oriented case for a semester, and then the final exam, if you will, is evaluated by sitting judges of an actual court. This is a unique opportunity for each of you because of the largesse of this court, which began 20 years ago when presiding Justice Gilbert said, let's do this, right? And has helped now more than a generation, basically, of law students. So we are extremely indebted to them for this.
And not, so I don't want you to interpret this as quid pro quo, but you are quite lucky. I'm not just saying this because he says such nice things about our court. Professor Glassman has appeared in this court ever since I started, I think, right? I think you were 12 years old then or something. He is one of the finest appellate attorneys we've ever seen. His briefs are, the clarity of his briefs, the brilliance of his arguments are really overwhelming. And he never disappoints. He's really one of the finest appellate lawyers we've seen in this court ever. And you're lucky to have him. I came down and talked to your class a few times. You're lucky to have someone of his brilliance and his insight as your professor.
And you
Thank
should
you.
go to court and you should go to court and watch him if you can.
Yeah.